My name is Jay Chauhan. This is the second video that I'm doing on the question of power of attorney. And in this video, I will give some more other details which I didn't do before in the previous video of what the types of power of attorney are. So in this video, I'm going to concentrate on the question of what is it that you need to do in a mechanical point of view to get the power of attorney created and then registered, etc. So first of all, my name is Jay Chauhan. I'm the head of the Angel Mentorship Group. Anybody is a lawyer in Ontario or outside can join the group, or a paralegal, or even a person in the community interested in legal issues. So I'll be talking about a number of issues, and I welcome your comments. If you want to broaden the knowledge of law to the lawyers as well as the students and the members of the community. And so that is the purpose of the Angel Mentorship Group on the Facebook. I hope you join. So I just want to talk a bit about the mechanical aspects of how you make the power of attorney effective. First of all, you appoint the attorney should be a person who has reasonable judgment and a knowledge of your attitudes and decision-making ability that you would make if you ask somebody else to make those decisions for you. For example, in the case of if you're a Jehovah's Witness and you don't want a blood transfusion, then the attorney that you appoint should have awareness of your abilities, of your inclinations and your attitudes that are known to the attorney that you appoint. So the first is a question of appointing a person who has the knowledge of your background, your attitude, your religion, etc. So person who is closest to you in your thinking process is the attorney that you should appoint. Then when you have the power of attorney signed, it is witnessed by two persons. Both should be watching, and the attorney that is being appointed should not be signing the power of attorney, because there is a certain amount of conflict of interest. You may be so therefore they should be independent witnesses. Very often there is a lawyer, but it doesn't have to be a lawyer, but very often there is actually. But that doesn't make it more enforceable. It is the witnesses who are independent, and if there's any question marks in your mind about the ability for the person making the power of attorney to have mental capacity, then you should make sure that you've asked the right questions. What questions would you ask? For example, the questions affecting the estate. You should ask the person making the power of attorney, what are your family members? Do you have a spouse? Would you first give the benefit to your spouse? Would you give it to your children? What authority would you give to the person who's closest to you in the power of attorney? Now, because of the broader nature in the estate power of attorney, to just basically, if it's a general power of attorney, to give everything away that you own, very often in more recent years has been called the living will. The living will essentially is a broad power of attorney that says that the attorney may have the right to make disposition of any asset. So you could write simply a check and take out the whole amount. But it's very important that if you're a lawyer advising the client, and before the person signs, you should make the attorney fully aware that the attorney, meaning the person who has the right and authority to do things on the behalf of the person signing the power of attorney, that you should make the person aware that the attorney is accountable. So when you write a reporting letter, you should let the person making the power of attorney know that the attorney is accountable and should be informed of his responsibilities. So, but your responsibility in making the power of attorney as a lawyer is to your client, who is the person making the power of attorney, not the attorney, but the person that you appoint. So I think that you should make your client aware of this division of understanding and responsibility when you're acting as a lawyer for the client. And if you're a client yourself and listening to the video, they should be aware of this distinction and the importance of understanding the nature of the power of attorney. So that brings to the question, forward the question. When you prepare the power of attorney, it is a general power of attorney. You may dispose of my assets and make decisions, etc. Or for a personal care, you make all the decisions for me. Can you basically change this power of attorney from the mental capacity? And I think that in terms of the capacity, I addressed that question earlier. So you should advise your client that the capacity is relevant at the time of changing the power of attorney, and you make your client aware, and that this power of attorney needs to be changed, then it can only be done at the time when the capacity is there. Now, so therefore, there is another question. Should you let the client know of the rights and duties and obligations that can arise from your job to revoke the power of attorney if it is specific? So what's a specific power of attorney? It is one where you prescribe in specific detail that I want you to dispose of my property and make a conveyance in my name, and therefore that person will be able to transfer the property in your name. So you will be able to make a change of the ownership, mortgage, and other disposition of the real property. Now, if it is very specific that that property to be sold and then registered to convey the property to another person, then it may be in Ontario, it requires to be on the register, on the Registry Act, the Land Titles Act, to be registered there. And if that specific power of attorney has been exhausted, meaning it is the duty of the attorney has been carried out in terms of what is to be done, then there is no need to have the revocation of the power of attorney done. But if it's general power of attorney, meaning that you can do anything and a part of what you're doing is been carried out, then you should advise your client that at some point in time you should not leave the power of attorney open and that you be revoked. How do you revoke it? You write a revocation letter to the attorney, make sure that comes to his attention, and let him know through the revocation that he no longer is authorized to make decisions on your behalf. And it would be very improper, if not perhaps illegal, for him to make decisions after that moment. So all the other persons at that time on a practical level that may be affected, such as the bank, you should let the bank also know that this person is no longer holding the power of attorney. So all the people that might potentially need to know who the attorney is should be notified that the power of attorney has been revoked. So just to summarize, a specific power of attorney does not always need to be revoked unless you see that there is a need to notify the person that he is no longer the attorney. If it is registered on the title to convey the property, you might need to register revocation as well, but only if it is needed and it is a general type of power of attorney. So I think I have mentioned to you the various practical aspects of the signing, registration, etc. And I think with all this sounds very complicated, but a lot of people I see are very often get from the website a power of attorney, and the basic question, if you're not a lawyer, is should you have a lawyer? In my view, it is much desirable to have a lawyer because although the power of attorney looks like a form, it has a lot of, some of the things that I mentioned to you just now, as you can see, is a lot of detailed complications behind the wording that are there to appoint an attorney. It's not that simple question that you pointed, therefore it is done as a job. So the forms that are available on the internet, I've seen many people signing those, using those forms, but a lot of the questions that are not inside the form can be relevant. For example, capacity, revocation, the duty of the attorney to be accountable for what they do. Every transaction, if you're an attorney, must be recorded because this is somebody else's money that you're handling, and the recording and reporting is the responsibility of the attorney that you appoint. So I think how much does it normally cost? I think that I think my observation of in most countries, in the countries, the people don't like to pay for legal fees, but here is an example of a very modest cost of $150, $200, $300 that you might need to pay to create a power of attorney and carry out your function legally very correctly. So I think that in places, in countries where there is reasonable amount of prosperity, then this amount is not a large amount and it can affect your entire estate. So it's very important that, in my view, for the public to realize that when you have a legal profession like medical profession, it is important to recognize that it costs money because the legal profession is private enterprise, the medicine is not, that you ought to consult a lawyer. And then the cost of $150 to $300 is not a major amount in relation to what you're doing and things that can go wrong if you didn't have the proper advice. So I hope that was useful. If you have any comments or new subjects that you'd like me to review, please write below on the Angel Mentorship group on the Facebook, and hope to see you again. Thank you.